agent of any law enforcement agency of a federal, state, county, city, or township agency present. This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Okay, number 2, this meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in the appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member, agent, or any law enforcement agency of a federal, state, county, city, or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand. Is there somebody?
Well, that's sweet. Thank you.
Somebody have a mic open?
All right.
I'm not sure where that's coming from. Please raise your hand, say your name, and state your position. This meeting is private, bearing false witness, misrepresentation, posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, township, or agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, state your name, and state your position. Raise your hand and state your position. Are we all clear? No hands raised. Awesome. Take it away, Glenn.
Okay, well, let's talk about a couple things here. First, I don't know if you heard, but Trump commuted someone's sentence. And so what exactly is that? Let's talk about that a little bit. It won't take very long to go over that. What does it mean when someone's sentence gets commuted? This is actually taken from one of my YouTube videos. I want to share. So, can you see that?
Yes, I do.
Well, I don't know. I'm sure you've all heard of penitentiaries. Did you know that a penitentiary is a place for penitents? It's an ordainer of penances, a place for penitents. That's Anderson's Law Dictionary, 1889 edition. And then penance. Penance is a punishment imposed for a crime by the ecclesiastical laws. It's an acknowledgement of the offense. Penance may be changed into a sum of money to be applied for pious uses called commuting. So Trump paid off the Roman cult. Anyways,
With what? A bill of exchange? What did he pay him off with?
Oh, that's their fake money.
Gold.
Probably gave him some fake money. But the bottom line is that it's a payoff.
Yeah, no, I like that. So let's see the note.
Yep. So, anyways, then the next thing I wanted to point out is, let me see if I can find it here. Oh, there we go. There we go. Let's show it on Telegram. People say the 14th Amendment's unconstitutional. And it's true. There's a lot of stuff that's unconstitutional. Matter of fact, and we'll talk a little bit more about this, but anyways, this is Luther versus Borden, U.S. Supreme Court. When a state forms a constitution which is approved by Congress, it's stopped to deny its validity. The action of Congress cannot be inquired into, for the judicial is bound to follow the action of the political department. So, and I have heard of people going in on a traffic court case, for example, and they'll tell the judge, well, you know, this case really comes down to what is money. And that's a political issue. And because under in the U.S. Constitution, Article 1, Section 10, it says that money is only gold or silver coin. But yet, if you go to Title 31 of U.S. Code, money can be a Federal Reserve note. So that's a political issue. And you all have an oath of office to support the supreme law of the land. Therefore, I think you ought to just dismiss this matter. And there's people I know of. Matter of fact, I've got a YouTube video with a guy that was a sound file that I got from this guy here in Texas that does exactly that. And he gets them dropped every time. He's got 3 of them, basically, and each one goes into more detail. But it's all the same argument, and the case gets dismissed because it's a political issue, and there's a lot of political issues. Whether the 14th Amendment is valid. I mean, the Congress itself has said that it's unconstitutional and not valid. But again, it's a political issue, because same thing with the 16th Amendment. They say that the 16th Amendment isn't properly ratified. Matter of fact, all the amendments after the 13th Amendment should say talk about titles of nobility. That's a political issue. And so, you just bring it up and say that it's a political issue, and they don't want to talk about it. So you ought to drop this matter. And it gets dropped. It's amazing how that works. So, anyways, that was the big thing that I wanted to bring up. And then what I was going to do is talk about my U.S. Court of Appeals for the Fifth Circuit. My case is now in the U.S. Court of Appeals for the Fifth Circuit. They sent me a letter telling me, well, I'll show you the letter here in a minute. This is my response to it.
Last week you told us about them breaking the First Amendment was your right to a religion.
That's true. That's the notice.
That was your reply, right?
No, that was a notice of constitutional challenge, and I'm going to bring that up in my appeal. But right now, they sent me a letter. I'll show you the letter here. But let's.
This week?
Sorry?
You got that this week?
Yes, it did. Yep.
And you told me nothing was going on.
Well, I just got some mail.
Oh, that's big. Come on. We have to reward ourselves with this shit. Come on.
Okay. So, let's see here. Oh, nope, that ain't it. There we go. Okay. So this is my response. Let's go first of all to the letter, and that's at the end. So we'll go down. I attach the letter to it. I always do that with this kind of thing.
Is this where they gave you back the 250 your filing fees?
Sorry?
This is where they gave you back the filing fees.
No. This is where they're telling me that I have to pay the filing fee.
Okay, I'm clear.
So this is the typical letter you get from the U.S. Court of Appeals. But notice it's Mr. GlennWinningham, non-domestic mail. Okay, non-domestic means it's not in the District of Columbia.
Sweet.
And it's got the USDC case here. And we'll go through the letter here in a minute. I'm just doing OCR on it because so that I can show some things.
I love that signature.
So I'm sending them a Form 1020. I did this last time, and I'll go into what happened and what I expect to happen this time. Weird. I did OCR on this, and yet it's not kicking in. Okay, well, so we've docketed the appeal, and there's the case number right here, 25-10360. Excuse me. And I must pay to the district court clerk $605. The docketing fee notifies of the payment within 15 days from the date of this letter. Well, this is going to go way beyond the 15 days, but it'll work fine. And failure to pay the fee within 15 days will result in a dismissal. So I've sent them. I'll show you what I sent them. And now it's talking about lawyers. They want they're who desire to appear in this case must electronically file. Okay. Well, I'm not a lawyer, so I'm not counsel. And so, but they're basically telling me to do electronic filing. Oh, here, if you're filing pro se without a lawyer, you can request to receive correspondence from the court or other parties by email. You can also request to file pleadings through the court's electronic filing system. And they tell me how to do it. Well, I'm not interested because, well, and I'll explain that in a minute. I'll go through and I'll explain why I'm not going to do it. But anyways, so these are all the lawyers that it's going to. Now, you got to understand that these, when it goes to the Court of Appeals, now they're going to have to all turn it over to an appeals lawyer, okay? And I guarantee you that they're going to have to pay $50,000 minimum, at least $50,000 to the appeals lawyer to handle this. $50,000 at least minimum, maybe $100,000. Anyways, so and this is the caption on the case. And I'm the appellant, and they're the appellees. So anyway, so this is my response. This particular one is my response to the filing fee. And that's the Form 1020. And we'll go through
the 1020.
Sorry?
You You've attached the 1020 as an exhibit.
Actually, I attached the letter to the 1020. That's why the 1020 is up front. So this is Form 1020, United States Court of Appeal for the Fifth Circuit, a private corporation. And this is addressed to the clerk, to the chief judge, to the circuit executive. Did you know they have a CEO? And then David Godby, the chief judge of the Northern District. And this is the case number. Notice to attorneys at United States Court of Appeals for the Fifth Circuit. An attorney for a private corporation is assumed to know the law. It's the obligation of an attorney or a private corporation to see that any alleged fines, fees, charges, etc. are collected lawfully, correctly, and completely in order to correctly, quote, pay this alleged fines, fees, charges, etc. GlennWinningham, House of Fern, requires the following information from attorneys at United States Court of Appeals for the Fifth Circuit. Complete this form and return it to the address you have on file to enable GlennWinningham, House of Fern, to understand and lawfully comply with this alleged fines, fees, charges, etc. This form raises formal questions with regard to this alleged fines, fees, charges, etc. that only your attorneys can answer. Under the caption, you must pay the district court clerk what does the number 605 refer to? Check 1. Obligations of the United States government, national bank currency, bonds, certificates of indebtedness, Federal Reserve notes, bills, or other. So they can put Silver Eagle coins, but they never fill this thing out. Okay? Anyways, does that statement refer to consideration of obligations or other securities of the United States directly or indirectly? Does the computation of this alleged clerk letter require consideration of obligations or other securities of the United States directly or indirectly? Yes or no? Most individuals can complete this form in 3 minutes. This is what I like about the Form 1020. It's really short and sweet. You're required by law to complete this form before any payment may be made. As a private corporation, you're assumed to know the law and not misleading. You made several statements in your clerk's letter to GlennWinningham, House of Fern that GlennWinningham, House of Fern knows something to someone. It's your obligation to answer the foregoing questions on Form 1020 or a default will be issued by GlennWinningham, House of Fern against United States Court of Appeals for the Fifth Circuit, a private corporation, for trying to mislead GlennWinningham, House of Fern by asking GlennWinningham, House of Fern for something that he doesn't know, or you don't know what that something is. So as attorneys, you're assumed to know the law. And then, I'm an attorney at United States Court of Appeals for the Fifth Circuit, a private corporation. I've read the foregoing Form 1020 and know it to be true, correct, and complete, not misleading in any way. I declare under penalty of perjury the foregoing is true and correct. Executed on, and the date, 2025, name, signed, and bar number. This Form 1020 must be completed and returned within 15 days of mailing. Delivery, filing, failure to complete and return this Form 1020 in 15 days will result in a default being prepared for United States Court of Appeals for the Fifth Circuit based on the information GlennWinningham, House of Fern has, and the default is your admittance that fines, fees, charges, etc. that was provided to GlennWinningham, House of Fern was an error or is in violation of the law. No other mailing will be needed. Failure to provide GlennWinningham, House of Fern with requested information in the time allowed, the attorneys at United States Court of Appeals for the Fifth Circuit are admitting with their silence that the United States Court of Appeals for the Fifth Circuit is dishonest. Estoppel arises where persons under duty to another to speak or failure to speak is inconsistent with honest dealings. Silence by United States Court of Appeals for the Fifth Circuit will be treated by GlennWinningham, House of Fern that fines, fees, charges, etc. as dishonest dealings, and balance is paid in full. And that's it. It's 3 pages. And then plus I attached the Court of Appeals letter. So anyways, now let me pull up the default. There we go. And let me just pull it up on Telegram. Now, this isn't completely done yet. There's a couple little things that need to be changed. I'm waiting for the first ones to get there, to get delivered. The post office is lousy. I tell you, there's really lousy service these days with the post office. Matter of fact, I'm thinking about sending the next one by FedEx or UPS. Just checking to see if it's coming through clear. Yes, it is. Good. Oh, and we got some people on YouTube. So this is what I'm doing. So this is the second notice that I'm going to be sending to the Court of Appeals. Once I get, it's got to be 15 days after it was served. So the first one was received, but it hasn't been received by all of them yet. The one to David Godby, that one's here in Dallas, so he's received that one, and the one to Jennifer Elrod has been received. But Lyle Case and Ted Caminos, these are new numbers here for the next serving. Those ones haven't been received yet. So then it says you're in default of providing a specie of payment, and you're notified that your attorneys have failed to complete the Form 1020 that was filed on 14th of April, 2020, by certified mail, and it's got the certified mail numbers and who got them. I've attached a copy together with proof of service for your reference. This has given me great evidence against you and your Roman cult handlers and your intent to engage in multiple felonies, violating rights and immunities under color of law, conspiracy to threaten, intimidate, coerce, injure me in the free exercise of my rights, mail fraud, sending threatening mail, impersonation, perjury of oath, and more. This is an effort to pay an alleged debt, and I'm going to give you another 5 days to provide a specie of payment as required by a Form 1020 that was served on you, or you're required to discharge this alleged debt under your Uniform Commercial Code 3.603. Have a great day. And that's a one-pager. And so then what I'll do is I'll attach the original Form 1020 with the clerk's letter, and then I'll attach proof of service, which is going to be the USPS website showing that all of them were delivered. And that's going to be the second one. This one's going to be, before I send it out, I'm going to change the date here. But I think that's all I'll need to change right now. I'll probably go over it real quick and make sure that, I got it. The date here is going to be whenever the last one gets it on the USPS website. And anyway, so we'll see. So then the next one, the final default,
You've already got that one prepared, right?
Yeah. Yeah, mostly it's gonna need some things changed, but it's gonna be mostly done.
Yeah, we were supposed to go over the 1020 one week, and I think we didn't get to it or something because you'd explained how it was created, but we really didn't catch the form and how the layout was. So can you post?
I can upload these to the group.
Okay,
if you
good.
want.
Yep, good. Yes, please.
So this is the final notice of default. And it starts off largely the same way, and those certified numbers are going to change. So it says you're in default of providing a specie of payment. You're notified your attorneys have failed to complete the Form 1020 that was served on the 14th of April. And here's the who they were served on. A notice of default and opportunity to cure was served on you on or about 1 May 2020. You failed to respond to that as well. Okay, so I'm going to have to make some corrections to this, like the dates for sure, and the certified mail numbers. True copies of which, together with proof of serve, are attached here too, all of which are incorporated herein by reference in their entirety. This was an effort to pay an alleged debt, and I needed to know how to lawfully satisfy this requirement. This is giving me great evidence against you and your Roman cult handlers, your intent to engage in multiple felonies, violating rights and immunities under color of law, conspiracy to threaten, intimidate, coerce, and injure me in the free exercise of my rights, mail fraud, sending threatening mail, impersonation, perjury, oath, and more. This is your final notice of default, and your failure to provide the required information means I owe nothing. Have a great day. And that's it. That's really simple. And I'll attach everything I did before that to it, right? So the notice of default and opportunity to cure will be attached, and the proof of service for all of those previous mailings will be attached. And that'll be it.
Yeah, it's a good ending. That's different than the previous ones that you've that have been submitted. So that'll be a new spin.
Yeah, so we'll see how it goes. What happened is last time I did this, after I got the whole process done, they sent me the scheduling order.
So that's like the trial docket, right? Where
no. The scheduling order is, after you pay the filing fee, they send you a scheduling order. The scheduling order tells you when you have to have your appellant's brief in. And it also will go out to the appellees, and it'll tell the appellees when they have to have their brief in. And so it basically tells you when you have to have your stuff in. And that's about it. And then you just follow the rules and prepare the paperwork the way the rules say to do it. And that's it. And you send them in. And if you have a response to the Court of Appeals, to the appellees are going to respond to my brief. And so I'm going to be sure, and I'll have a certain number of pages. Has to keep within a certain number of pages. I'll have to. Usually, there's a certain color. I have to have a certain cardstock color that I have to make all my briefs.
has to be in a binder. Has
to be bound, but that can be a staple. And so. But there's rules. They have their rules they make you follow. And
yeah, like 20 different ones.
Oh, there's a bunch. But anyways, it's not overly complicated, but they have their little rules, and so you have to jump through their hoops. Anyways, remember in that other document, they wanted me to do electronic filing. So this is my response to the electronic filing, and I sent this to the clerk. Okay, the rest of them didn't get this, but the one that I sent to Lyle Casey got this. The rest of them just got the Form 1020. So this is my response to the District of Columbia Corporate Clerk's impecuniosity interrogatory and electronic filing agenda. And the impecuniosity interrogatory. The demandant will gladly complete the impecuniosity interrogatory with the District of Columbia clerks masquerading as judges when they provide a bona fide Article 4 amendment search warrant signed by an Article 3 judge with a court seal as required by the Authentications Act, requiring the demandant to provide any personal information based on probable cause of a crime supported by the oath or affirmation of a competent witness. Fails to be a government employee, and it must include the specific information required. Excuse me, this is the Fourth Amendment. The electronic filing agenda. The demandant will gladly complete the electronic filing requirements with the District of Columbia clerks masquerading as judges when they provide the law that requires the demandant to get or use a Social Security number for their electronic filing in order to get a credit card and when they provide the law that requires the demandant to get or use a credit card or a debit card or even a bank account for their electronic filing agenda, and when they provide the law that requires the demandant to get a government-issued identification papers or plastic as required by their bankster buddies, as required by the District of Columbia electronic filing, and when they tell Yarborough and Simonton — Yarborough is the FBI special agent in charge, and Simonton is the U.S. attorney — to arrest and prosecute the bankster thieves for their felonies, when they close the demandant's bank account for failure to provide a Social Security number, failure to provide a government-issued identification, when they provide their authority to convert the demandant's right to justice in this matter into a privilege, when they provide a bona fide Article 4 amendment search warrant signed by an Article 3 judge with a court seal as required by the Authentications Act, requiring the demandant to disclose the Social Security number, disclose the credit card number, or bank account number, or name or address, or government-issued identification for their electronic filing agenda. The demandant's a living man, fails to have a Social Security number and that the banksters require for a credit card or a bank account. The demandant's a living man and fails to have a credit card or debit card. The demandant's a living man and fails to have a bank account. The demandant's a living man fails to have a government-issued identification card that the banksters require, mostly because the demandant fails to be a government employee. The demandant has filed felony criminal complaints with Chad Yarborough and Leah Simonton and their predecessors about Coinbase, Wells Fargo Bank, Frost Bank, Bank of Texas, Regions Bank, Comerica Bank, Compass Bank, PNC Bank, and TD Bank for their forced KYC, Know Your Customer, Social Security Number, government-issued identification requirements after they closed the demandant account, some of which have been in place for many years, for failure to provide a Social Security number or government-issued identification, and Yarborough and Simonton and their predecessors absolutely refused to do anything about it. The demandant did file a suit against Wells Fargo Bank in the lower so-called court as case number 414 CV 853A, and the clerks masquerading as judges dismissed it for failure to pay their District of Columbia securities / Federal Reserve notes / IOUs / forced loans extortion, evidencing their intent to sell their justice, justifying the refusal of Yarborough and Simonton and their predecessors to prosecute the felonies. The fact that the officers of this so-called court are demanding their impecuniosity interrogatory in their electronic filing scam is proof that they failed to be lawful Article 3 judges, but actually bought and paid for administrative clerks masquerading as judges, thereby disqualifying themselves, given that the issue in this case are core issues involving life, liberty, or property. And here's a bunch of court cases. Non-judicial officers cannot perform judicial duties. Lots of cases that talk about that. The demandant has lots of first-hand knowledge of how the officers of this so-called court intend that these wrongdoers named herein and others engaged in the theft of the demandant's land, because they can then justify forcing the demandant to give evidence against himself, to force the demandant into their satanic commercial District of Columbia dictatorship. So either way, it's a win-win-win scenario for their Satanist Baal priest officers of this District of Columbia so-called court. The demandant has lots of first-hand knowledge of how the officers of the so-called court intend that the wrongdoers named herein and others engaged in multiple felonies and enslave the demandant because it brings them so much business. And also because they can then assault the demandant with their District of Columbia commercial dictatorship, with their fake money and their bankster thieves and their electronic filing scam, so they can justify assaulting the demandant with their minor estate, treasury direct account, and enslave the demandant and steal the demandant's land. The demandant demands that the District of Columbia clerks in this corporate so-called court provide relief against their U.S. citizen wrongdoers named herein. And anyways, there's a bunch of court cases that support that. By regulating their property as required by Article 4, Section 3, Clause 2. Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, which is the supreme law of the land, anything in the constitutional laws of any state to the contrary notwithstanding. And that's Article 6, Clause 2. But they're acting as accomplices, busy fabricating evidence, assaulting the demandant with their Commerce Clause, Article 1, Section 8, Clause 3, with their electronic filing scam, evidencing their intent to bring the District of Columbia dictatorship outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. And in other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even in one of the several states, though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. But it's nothing personal. It's just business. Assaulting the demandant with their color of law minor estate, and then the Satanist Bill priest can call it a contract. Failure of the bought and paid for clerks masquerading as judges in this District of Columbia so-called court to do their duty to regulate their corporate property, and failure to vigorously prosecute them for their felonies might result in the demandant resisting their slavery scam with lethal force if necessary by hunting the wrongdoers down and to complete a commercial transaction by blowing their fucking brains out, since they want to do a commercial transaction so bad, and call that a contract. And if the wrongdoers kill the demandant when he resists their slavery with lethal force if necessary, the Satanist bail priest officers of this so-called court get to pillage all the fake money in the minor estate treasury direct account for themselves and their thieving bankster handlers under the Hague Convention concerning the international administration of the estates of deceased persons, concluded 2 October 1973, which is what they've intended from the beginning, as evidenced by the minor estate treasury direct account, which is a dead thing, which means it's a win-win-win scenario for the officers of this so-called court and their bankster handlers, which evidences their refusal to prosecute the 78 felonies, because it has nothing to do with the law, which these Satanist bail priests have nothing but contempt for, but it is political. And they're giving aid and comfort to the enemy in a time of war. When the demandant turns up dead, this document will be demandant's deathbed testimony. The demandant's not suicidal, but he's also a cantankerous old fart and has lots of aches and pains, and the sooner he's out of this fucking hole, the better. With thieves everywhere, especially in the fake government and the government employees that perjure their oaths at the drop of a hat, and the bought and paid for clerks masquerading as judges in this so-called court, and the demandant's conscience is clear, and he's ready to meet his maker, so go ahead, make my day. We're all here before this universe is created, and we'll all be here when it goes away, and before God, angels, and anyone who reads this as a witness, the demandant shakes the dust of the earth from off his feet against these wrongdoers named herein, and the officers of this District of Columbia so-called court, and we'll be talking about this on Judgment Day, before the judgment seat of the true God on Judgment Day. Signed and sealed in red ink. Anyways, I was kind of railing there. So that's that one.
Don't get me going.
Don't get me going. That's right. So I have been updating my. Let me see here. I have been updating my notice of constitutional question, notice of constitutional challenge. I'm still not done with it yet, though. So, I mean, we could go through what I have there, or we could go through something else. I covered, let's see, how long have we been going? This has only been 40 minutes so far, so we're still relatively early on this.
Everybody's got
Sorry?
Everybody's got lots of steam left. Keep going.
Okay. Well, so we went through all of the Form 1020 documents. And we went through why it's, do we want to go through my revised brief in support of the notice of constitutional question? I've made some changes to it. It's largely the same as the other one, but I've added some things. Oh, let me... Sorry?
Show us the add-ons.
Okay. Let me just add, before I get too carried away here, let me upload these Form 1020 documents, the Word files. Okay, these are going to be just the Word files. Do you want me to upload the response to the impecuniosity interrogatory?
Absolutely.
Okay. So I'm uploading those to the group right now.
Yeah, why did you not ask them to define pay? Or I guess maybe you didn't want to make your document longer than it need be, but
yeah, that's adding in stuff. They quote pay. I put down, that's why that form was developed by Kerry Zolman, and it's brilliant. And the thing with anything is you don't want to make it too long. And the fact that that's like 3 pages is brilliant. It's short and sweet and gets to the point. And it's an offer to pay, and that's what I'm saying. And that final notice of default is going to be changed. I'm probably going to add in something about the Uniform Commercial Code at the end, saying that they have to discharge it. So there's going to be some tweaks, that'll happen. But so I uploaded those 3 documents to the Telegram group. Let me. So this brief is going to be a little bit longer now than it was. And
thank
what
you,
I'm.
thank you for that.
Sorry?
No, I thank you for doing that. No, I thought last week you were going to be sending that out this week.
I did send out the first one. The brief was already filed. It's already been filed in the federal court in downtown Fort Worth. The I may not. This is according to the federal rules of civil procedure, and everything done in the Court of Appeals is done according to the rules of appellate procedure, which is a different set of rules. Now, so I may not actually file this again, but I'll definitely use the text that's in it, and in the Court of Appeals, among other things. I'll use other stuff too. So let's I'll share that with the Telegram group, and I got to share it on YouTube. Oh, there we go. Okay, so this is the brief in support of the notice of constitutional question. I'm just waiting for it to show up on YouTube. The Telegram group is called We Are Law. We, and then the letter R. So it's We Are Law. And so for anybody on YouTube that wants to join and participate, there's some really interesting people on that group. There's a guy by the name of Ron Adams that's a forensic accountant, and he can pull up all sorts of information about mortgages and all sorts of stuff like that. But so there's some pretty interesting people on that group.
Rick Martin.
Yeah, Rick Martin. Yeah, I went and actually was it Rick Martin that I saw in Phoenix? I think I did meet with Rick Martin in Phoenix, and we had a nice little visit. I think so.
Yeah, he was talking about it one night when he was chatting with us. Yeah, he knows your work well. Right.
Yeah, we had a nice visit. We went and it was at a Safeway, and then we decided to go over to the IHOP. Matter of fact, what happened is we were talking about the schools, and there was people overheard us talking, and so a school teacher with her daughter came over and was talking to us about the schools, and that was in Arizona. And I thought that was quite interesting, and it was good that they were, the people were listening. So anyways, this is the brief. Comes now the demandants providing notice to the bought and paid for clerks masquerading as judges that in this inferior legislative court and their executive branch congressional handlers in the District of Columbia, that their 1871 corporation at 16 Stat 419 domiciled in the District of Columbia and its minor estate scam at 31 CFR 363.6 are violations of the organic laws as follows. First of all, there's 4 organic laws of the United States of America: the Declaration of Independence, the Articles of Confederation and Perpetual Union, the Northwest Ordinance, and this Constitution for the United States of America. So it's not just the Constitution that they're violating. They can violate any of those documents, and there's a problem. The District of Columbia 1871 Municipal Corporation is a violation of the organic laws because it is Roman law from the Vatican. And this is Black's Law Dictionary, 4th edition. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law, which violates Article 1 and Amendment, which requires Congress shall make no law respecting an establishment of religion. And that's the First Amendment. And is bringing in the Vatican's Roman law into the land of America, which uses fraud and deception to supersede and replace common law. And this is, there's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command or crimes. Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense and in the same enactment provide exceptions to its application. As found in the Causes and Necessities for Taking Up Arms, 1775. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the custom and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. Despotism is dictatorship. And it was also talked about as some of the reasons for the separation from the tyrant in the organic law of the Declaration of Independence. He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses, for imposing taxes on us without our consent. And these two here are directly talking about that minor estate too, by the way. For depriving us in many cases of the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments. He's abdicated government here by declaring us out of his protection and waging war against us. And that's exactly what's going on today. Okay, if anybody's in court, if you don't understand you're at war, you're going to lose. It's warfare. It's all warfare. What was it? Jefferson said, a republic is the only form of government that isn't at open or secret war with the rights of mankind. Well, we have a tyrant. Because common law is the law of the land, which has always been here. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state. That means long before. Hale versus Henkel, 1906. And it is full of fraud and deception, which is the same reason why we took up arms against the Vatican's tyrant for all of the grievances listed in the organic law of the Declaration of Independence. The minor estate in that the County of Montague and the Vatican's bar members and the Vatican's bought and paid for clerks masquerading as the judges have assaulted the amendment with is also a violation of the organic laws under Article 1, an amendment which requires Congress shall make no law respecting an establishment of religion. And this is the First Amendment again. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The minor estate is created by the Vatican, yet still it was found difficult to set bounds to ecclesiastical ingenuity. For when they were driven out of all their former holes, they devised a new method of conveyance by which lands were granted not to themselves directly, but to nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy. Isn't that convenient? The Vatican gets to run the courts, and that same thing is going on now. To be bound in conscience to account to assess to use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. Use is short for usufruct. That's Roman law. That's taken from Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And by the Vatican's tyrant with the Sestica V Act of 1666, which is for land titles, and was brought into America with the Code of Law for the District of Columbia at 31 Stat 1432, where it says the legal estate to be in the Sestica use, which is talking about land titles, and a use is short for usufruct under Roman law. Those things which perish by capitis diminutio, of which kind are of usufruct, an obligation to services on the part of freedmen contracted by oath, and matters enforceable by a statutable action. And that's taken from the commentaries of Gaius and Rules of Ulpian, translated with notes in 1874, which is a type of a trust. And a U.S. citizen minor estate entity is a taxpayer. Every taxpayer is assessed to a trust having sufficient interest in preventing abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. And that's Henry Boland's, a summary from Henry Boland's 1912. I've heard of some people going into court, as a side note. I heard, we were talking today, and I've heard that some people go into court and they'll take the birth certificate in there and they hand it to the judge. And they say, I'm appointing you to be trustee, I'm a beneficiary, and they point at the prosecutor, he is fraudulently attempting to be the beneficiary. And what they said is when that happened, the judge and the prosecutor get it into a heated discussion. And the case
Yeah,
goes
they start ripping off all their clothes and or taking off the robe and throwing the wing at the prosecutor.
They didn't do that. No, what they did was again, you're accusing the prosecutor of trying to be a beneficiary, and you're giving them evidence that you are the beneficiary, and so now there's a problem here. There's some fraud going on, because that's what they're trying to do. They're trying to be the beneficiary.
On that letter there, that response you showed us earlier, that signature was signed by the clerk's beautiful signature.
Yeah.
So there you go.
Well, they do that all the time. Anyways, okay. Citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the Public Charitable Trust, the Constructive Sestica Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. And that's a summary taken from the Congressional Record, June 13th, 1967, 5 pages of the Congressional Record. I don't know if anybody's looked at the Congressional Record, but it's 3 columns and very fine print. And so that's a summary of what's taken from there. The Vatican, so don't be going looking there. Don't be contacting me and saying you can't find it. Well, it's not there. It's a summary. Read the whole 5 pages, and that's a summary of what that says. The Vatican's minor estate creates the presumption that everyone's dead because it is political. When a state forms a constitution which is approved by Congress, it's a stop to deny its validity. The action of Congress cannot be inquired into, for the judicial is bound to follow the action of the political department. And the dead have no rights and fall under the Commerce Clause as described below. The Vatican's minor estates also talked about for some of the reasons for the separation from the Vatican's tyrant in the organic law of the Declaration of Independence. And he's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments. He's abdicated government here by declaring us out of his protection and waging war against us. And as found in the Causes and Necessities for Taking Up Arms, 1775. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the courts of common law and instead thereof to publish and order the use and exercise of the law martial. And for altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us. So that's why you can't mix your law. Okay, you cannot mix your law. If you mix your law, they'll just ignore it. If you have a good judge, he'll actually say you're crazy. You need your head examined. And if you have a bad judge, he'll sit there and play stupid and ignore everything you say and rule against you and let you figure out what happened. Janet Yellen and her predecessors used the Vatican's fraud and deception of their minor estate entity, GlennWinningham Fern, in all block capital letters. Now I say that the heir, as long as he's a child, differeth nothing from a servant, though he be Lord of it all. And that's Galatians 4:1. To use it as justification to assault the demandant with the Commerce Clause, Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17. To deceptively assault the demandant with a quasi-contract. Assumpsit, in its origin an action of tort, assumpsit was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract. Based at first only upon an express promise, it was afterwards supported upon an implied promise and even upon a fictitious promise. Introduces as a special manifestation of the action on the case, it has soon acquired the dignity of a distinct form of action which superseded debt. So look at these are commercial words, okay? Superseded debt, became concurrent with account, with case upon a bailment, a warranty, and bills of exchange, and competed with equity in the case of the essentially equitable quasi-contracts. Growing out of the principle of unjust enrichment, surely it would be hard to find a better illustration of the flexibility and power of self-development of the common law. And this is a history of assumpsit. Both in Roman and English law, there were certain obligations which were not in truth contractual, but the law treats as if they were. They were contractual in law, but not in fact, being the subject matter of a fictitious expansion of the sphere of contract to cover obligations which in reality do not fall within it. Which requires the Vatican's minor estate, U.S. citizen, or other fiction. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. So the Vatican's bar members of the County of Montague Corporation can assault the demandant with their Texas tax code with their forced rendition, which is why they use the Vatican's fraud and deception of capitis diminutio. Capitis diminutio is the destruction of the caput of legal personality. Capitis diminutio, so to speak, wipes out the former individual and puts a new one in his place, and between the old and new individual there is, legally speaking, nothing in common. A juristic personality may thus be destroyed in one of three ways. One, by loss of status libertatis. This is the capitis diminutio maxima. Two, by loss of status civitatis, which is capitis diminutio media. And three, by severance from the agnatic family, which entails capitis diminutio minima. And that's the Institute's a textbook in history of the system of Roman private law. And that's Black's Law Dictionary, 8th edition. Capitis diminutio maxima, meaning the maximum loss of status through the use of capitalization. The highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away with it all rights of citizenship and all family rights. And that's Black's Law Dictionary, 4th edition. Because the Vatican's fraud and deception of capitis diminutio maxima is used when they enslave people, and they are Satanists using fraud and deception to sell people into slavery as collateral for their minor estate. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state, which are non-judicial proceedings, because whenever a statute's involved, the Vatican's fake judge is actually a bought and paid for clerk masquerading as a judge. When acting to enforce a statute and its subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule, not only of state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for an agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency, which is why it's a bill of pains and penalties, similar to a bill of attainder in violation of the organic law. This Constitution for the United States of America, Article 1, Section 10, Clause 1. I need to silence my phone. It's making all sorts of noise here. There. So, Article 1, Section 10, Clause 1, and Article 1, Section 9, Clause 3. A bill of attainder means a legislative act, no matter what their form, that apply either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. A bill of attainder is a special legislative act prescribing punishment without a trial for a specific person or group. Bills of attainder are prohibited by the U.S. Constitution, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. That's Black's Law Dictionary, 8th edition, page 496. A bill of pains and penalties, a legislative act, though similar to a bill of attainder, prescribing punishment less severe than capital punishment. Bills of pains and penalties are included within the U.S. Constitution ban on bills of attainder. And that's Black's Law Dictionary, 8th edition, page 499. I'm just looking at the comments in YouTube. We got, looks like 27 people watching on YouTube right now. Also means they have no... Sorry?
What's the name of your YouTube channel?
Sovereign Living. All one word. It's got Scales of Justice as the logo.
Okay, I'll check it out. I'm listening on Telegram. I wanna follow up with some of those codes you speak with. I yield. Okay.
Also means they have no authority to do anything judicial and are fraudulently and deceptively presenting themselves as a court of law. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Their legislative inferior court might be a superior court of general jurisdiction under some circumstances. A court of general jurisdiction is presumed to be acting within its jurisdiction till the contrary is shown. But when a superior court of general jurisdiction undertakes anything that's in derogation of common law, it becomes quad hoc, an inferior court of limited jurisdiction. to be that statutes which would deprive of citizens of the rights of person or property without a regular trial, according to the course and usage of common law, would not be the law of the land. And their maritime codes have absolutely nothing to do with common law. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. See Book 21 of Corpus Juris Secundum, Courts, Section 2. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. See Book 20 of American Jurisprudence, 2nd edition, Courts, Section 103. It is familiar law that when statutory authority and derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc a court of inferior or limited jurisdiction. Therefore, it's actually an administrative hearing for their maritime code. A ministerial act is an act that a public officer is required to perform in a prescribed manner in obedience to the mandate of legal authority and without regard to his own judgment or opinion concerning such act's propriety or impropriety. When a given state of facts exists, discretion, on the other hand, is the power conferred on public functionaries to act officially according to the dictates of their own judgment. When acting to enforce a statute and its subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but not in a ministerial, but only in a ministerial, not a discretionary capacity. It's the accepted rule not only in the state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for an agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, act as mere clerks of the involved agency, which is a fraud and deceptive, which is satanic because it's actually an executive agency working for the executive branch. The Telegram channel that this is on right now is called We Are Law. We, and then the letter R in all block and capital letter. So it's We Are Law on Telegram. Which is full of fraud and deception and satanic because there is no judge for that proceeding, but is actually a bought and paid for a clerk masquerading as a judge that cannot do anything judicial. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Where there's no jurisdiction, there's no judge. The proceeding is as nothing. Such has been the law from the days of Marshal Saya. And that's a federal case, Manning versus Ketchum, quoting a Supreme Court case, Bradley versus Fisher, which is quoting 10 Coke 68, which goes back to the 1500s. To put the demandant into bondage, selling the demandant into slavery as collateral for the Vatican's minor estate is described in 31 CFR 363.6 because an entity includes the estate of a living person such as an incompetent or a minor. Entity means any owner of a treasury direct account that is not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company, trust, the estate of a decedent, or the estate of a living person such as an incompetent or a minor. And a minor can be an individual who's attained the age of 18 years but has not yet taken control of the securities in his or her minor account. Minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. They're fraudulently and deceptively using the Vatican's minor estate to bring the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may by session of particular states and the acceptance of Congress become the seat of government of the United States, which is using the Vatican's fraud and deception to unlawfully place the demandant under the Commerce Clause. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company, the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. The plenary power is a dictatorship, okay? Plenary jurisdiction, the court's full and absolute power over the subject matter and the parties in the case. Plenary is full, complete, entire, plenary power. Complete power over a particular area with no limitations. The term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The courts have found that states are not able to pass law affecting interstate commerce without the permission of Congress. And that's taken from Legal Information Institute, that's Cornell Law School, which is the despotism talked about in the Cause and Necessities for Taking Up Arms, 1775. We saw the misery to which such despotism would reduce us, which is why the Vatican's bar members are name-calling the demandant a sovereign citizen like it's a bad thing when they know the House Joint Resolution 183, dated May 3rd, 1940, at 54 Stat 178, says in the preamble, whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. And the Vatican's bar members are required to know that the Supreme Court of the United States has ruled that everyone and everything not privileged is sovereign, all of which evidences their intent to perjure their oath to support the supreme law of the land, Article 6, Clause 2, and make war on the Republic and engage in all the reasons for the separation from the Vatican's tyrant listed in the organic law of the Declaration of Independence, this is prohibiting the free exercise of the demandant's religious beliefs in violation of Article 1 and Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. As a Christian, because the demandant has a right to own land under natural laws found in the Holy Bible. Every citizen and freeman is endowed with certain rights and privileges to enjoy when no written law or statutes required. These are fundamental or natural rights recognized among all free people, which is satanic because the Vatican is a necromancer with their minor estate or is bringing dead things to life and prohibited under God's laws found in the Holy Bible. There shall not be found any among you anyone that maketh his son or his daughter to pass through the fire, or that useth divination, or an observer of times, or an enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all that do these things are an abomination unto the Lord, and because they are abominations, the Lord thy God doth drive them out from before thee. Deuteronomy 18:10-12. And they are using fraud and deception of the Vatican's minor estate to engage in the theft of the demandant's land to populate the prisons by selling people into slavery. And if we're a Christian nation we claim to be, they would get their necks stretched. If a man be found stealing any of his brethren of the children of Israel, and maketh merchandise of him or selleth him, then that thief shall die. Thou shalt put evil away from among you. And all fraud and deception and lies come from the devil and Satan. You have your father the devil, and the lust of your father he will do. He was a murderer from the beginning, and abode not in the truth, because there is no truth in him. When he speaketh a lie, he speaketh of his own, for he is a liar and the father of it. I know the blasphemy of them which say they are Jews or Christians, and are not, but are the synagogue of Satan. And that's all I've got at this point. I might add some more stuff, but that's about it. That's 12 pages. So that's I may not. I doubt I'm going to file it like that. I'll probably use the text though, and so I'll still continue to massage the text because I'll need the text when it comes time to making my appeal brief. So, anyways, just looking at the.
There's some gems in there. I like the sovereign citizen, but no argument.
Yeah, well, let's see. This is laying the foundation for my next lawsuit. So I want to see what happens, and I'm not sure if I'm going to let it finish at the Supreme Court before I file a next lawsuit or not. But I've got another lawsuit. They've actually told me that I have to file a lawsuit. The courts sent me a notice of deficiency, so I'm going to have to file it. But anyways, one thing I wanted to make everybody aware of is my Northeast private information share is coming up pretty soon.
You have anybody coming from overseas again? Scotland?
No, not right now that I know about.
Didn't some guy come from Scotland that used a world passport and had no issues?
Yeah, actually, he was from England. He had been a police officer in England for many years, but he left because he saw the corruption and didn't particularly like it. So he retired from the police in England. And he's actually talking about coming again, but he's not from there. He lives here in America now. He's got a wife here, and so he lives here in America now.
Smart.
He's
considering what they're doing here. Let me know when you're ready for some updates. What's going on here?
He's things are really yeah, let me just show this real quick. This is my Northeast private information share email that I put out. So we're going to be doing our Northeast private information share on the 12th and 13th of April, the 19th and 20th of April, and the 26th and 27th of April. It'll be in Ocean City, New Jersey. It's 2 blocks from the water. And if you when you pay for the room or you pay your tuition, then the room comes free. And so it's $100 a weekend for anybody that hasn't been there before. And then anybody that has been there before, it's $50 a weekend. And they're beach houses. They're 2 blocks from the beach. Life's a beach. And so for anybody that wants to come. And for me...
And you cook steaks too, right?
Well, I can. If someone... I like steaks, but I mean the kitchen. It's a full house. I mean, it's got kitchen, all of the everything you need. It's just like a little. I get a chance to get away from it all, So there's 2 beach houses, and there's like 4 kitchens, and there's like 17 bedrooms and 10 bathrooms, and so there's 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 and a lot of the bedrooms have bunk beds and stuff in them. So if there was a lot of people that showed up, there'd be room. But anyways, and it's a great place to go. It's the off season, so there's not full of tourists and crap. And so a lot of times we wind up going out and having seafood somewhere at one of the great seafood restaurants. I mean, it's on the beach, right? Life's a beach.
Yeah, stop bragging.
So anybody want to come, then we'll be there. I know Queen is in New Jersey, so but I'm not sure. She's quite a ways away, I think. So, anyways. So give me some updates here, Lori.
When is it?
12th and 13th of April, 19th and 20th of April, and 26th and 27th of April.
Yeah, I'm going to try to come.
Okay. Well, if you make it, that's great. If not, maybe next time. We're doing it just on the weekend. We're doing it just on the weekend this time. Last time we did it on Fridays too, and we figured that a lot of people can't come because it's Friday. They still have to work, So, anyways. What's the updates there, Lori?
Okay, well, the craziness up here is that they love protesting in Vancouver, right? So you know how everybody's a Trump hater up here. So this weekend, apparently, there's going to be a huge police presence everywhere because everyone is protesting against Elon Musk, right? Because he's supporting Trump, right? And they're all, the EV vehicle thing, the hoax, they're all kind of going crazy and berserk about these electric vehicles that Elon Musk apparently really doesn't care about because now he's created something else that's the AI that's worth triple the amount that all the EV motors and Tesla, or they're actually protesting Tesla. So we're getting enormous police presence due to protesting Tesla. Do you believe it? How useless can they get?
Well, they're all military police.
They don't do anything. They go there and they agree with the protesters and say, we wish we could be on your side. It's just ridiculous. Yeah, I did that crazy protesting thing at the beginning of the great hoax, our latest great hoax, and the chaos that went on was just all a big show. So that's the update I can give you for about where I'm sitting. It's just more useless stuff. And then, of course, they have an election where Trump's best friend has taken over for Justin Trudeau for the month. And, of course, nobody likes the Liberals anymore after what Justin Trudeau's done. So if it's going to be a selection like it is every year or every election, it's not an election, it's a selection, right? So if they put Mark Clarney, Trump's best friend, in again, they select him, and apparently he's supposed to be stepping down right away so that they can put in Christy Freeland to run it in her normal Nazi style. So it's all just a big setup for hating Trump. Trump's part of it in Canada because he's bringing in all the tariffs and creating all this chaos. But Elon Musk, they got to take it out on Elon Musk because he's a Canadian citizen, right? So I'll let you know what goes on through the weekend. But I'm not participating.
I think a lot of those protesters are paid.
Oh yeah, Antifa shows up at all of them and gets the crowd going, right, with doing stupid things where the police get set off, and it just creates more military presence, which Canadians seem to enjoy. Because to go out and protest is just a completely useless thing to do, in my opinion.
Yep, I guess we'll see how it all plays out. I think Trump is, there's people that like him and people that don't like him, but he's any way you want to look at it, he's way better than the communists that were in power, and so I guess we'll see what happens in communist Canada, but that's going to be my next lawsuit. Actually, is I'm going to sue the U.S. consulate in Calgary, the couple officials up there, and I'm going to sue the. There's a bunch of people I'm going to sue, but anyway, so we'll see what happens. But I want to let the dust settle from this one. It'd be nice to get a favorable ruling about that minor estate. I'm saying it's unconstitutional, and the DC corporation's unconstitutional. And I'm actually thinking about adding a bar into the National Bar Foundation. I think that's unconstitutional too because it's the Vatican. But so, anyways, I guess we'll see.
Well, anybody who's getting a pension from Canada, it's been announced that you can file a 10 or a T5 form, and they can no longer take any voluntary taxes from you. So that was not just announced, but it was stipulated on a form that was hidden, and now it's been known. So if you know any Canadians that are getting pensions that are all being taxed because those accounts are all securitized, all they have to do is request a T5 from Revenue Canada, and all their taxes will be returned, and you will be exempt from that moment on.
Wow,
so
that's interesting.
Yeah, that's good news for us poor folks up here.
Well, Canadians, they tax the heck out of you.
Well, that's because they're so dumb and they volunteer for it all. They don't read any laws.
It's all tied to that minor estate.
Slavery, don't get me going. So, last week with getting that reply from the appeal court, that was pretty big news. So don't let that stuff wash again, please. That's kind of exciting for me anyway. I enjoyed hearing that reply, even though it isn't any answer that's or decision that's been made or anything, but it's definitely a step in the right direction, and those small steps are big steps on this side.
Yep. Well, so I guess we might as well wrap it up. It's been an hour and a half. Is there anybody got any questions or anything about what we talked about tonight? I'll
be in my cog. Okay, that very first case that you read regarding, just talked about where you got the offer on that lot, or you're finalizing it. Have you, by any chance, read the 10-year township plan for that area and why? Maybe get some more clear understanding of what they're going to be doing in that area in the next 10 years of why, it's such a hot potato right now and why they want it.
No, I haven't, and I'm just kind of glad to be done with it. And I'm getting a whole lot more than I paid for it. I'll probably get about $3,500, which I'm not into it for anything at this point, and just a lot of hassle. And I'm tired of fighting with them. I don't think my land where this lawsuit that's in the Court of Appeals, that's in Montague County. It's a different county. It's a different land. And I'm sure they don't want to talk to me anymore. I haven't heard a peep out of them, but I'm not done. They drew first blood. They started this. I'm going to finish it. I'm going to break it off in their ass. I told them when they went and did this shit, I told them, I said, I've been to the U.S. Supreme Court 5 times, and you're next. You know how much it costs to go to the Supreme Court just for the cost? And that's all I said to them. But I can tell you that you could do a Google search and see how much the average cost to take a case to the Supreme Court is if you have to hire lawyers. And they have to hire lawyers. It costs about $2 million.
The bonds that you said they have to put up just to start everything is about $600,000.
Yeah, I'm not sure about that. I don't really, that's talking commercial stuff. There's a lot of unproven theories about that. I'm sure they have to put up bonds and stuff like that, but that's nothing to do with me. That's all commercial. And I try and stay away from the commerce stuff. I think it's satanic. And the Declaration of Independence is full of grievances about that kind of stuff. And so I think that it's who knows? I could wind up bringing a huge landmark case. I don't know. I guess we'll see, but I got to fight it. I'm not just going to roll over. And I think that maybe it's possible that, I've been to the Supreme Court 5 times. Well, this might be the one that is the silver bullet. Who knows?
Well, I think you're leading them to where you wanna go.
I had a dream.
Yeah, it was nice listening to you, Glenn. I'll follow your case. Keep it in the Telegram. I'll follow along.
Okay.
I doesn't make it to the beach event, but I'm on the other side of the country.
Where are you at?
I'm in California.
Oh, communist California.
California.
I've heard it called that. I'm in the mountains, in the hills, and I'm fighting for my rights up here, standing in my square.
There's some people I know in Grass Valley, California. It's gorgeous there, and there's a major networking group in Grass Valley, California.
Okay.
I don't know how far that is from you.
I'm in Southern California, in Riverside County, unincorporated landmass.
Oh yeah, okay. Well, I can tell you that I'm a senator with the Republic of Texas, and if you know anybody down there that has to do with the Republic of California, then we would like to open up negotiations for a treaty of peace and recognition.
What's
Okay.
that?
That's what sovereign nations do. Is do treaty of peace and recognition. We agree to be peaceful, and we agree to recognize you as a sovereign nation.
Is that filing your public organic record into the public record? Your peace treaty?
No, actually, we would probably file it with the UN if we did have a treaty.
Oh, okay. All right.
But so, anyways, all right. Well, I guess if that's about it, then I guess we'll cash it in for today. And we'll meet same time, same place, same channel next week.
Sounds good. I like that we chatted during the week so that I could know you were going to be here before 4 o'clock Friday afternoon. It would just made the day go a lot smoother. So I could, make sure that you were going to be around and at what time zone so I didn't miss you or vice versa, You know how it goes when we're not on the same part of the rock, right?
Yep, I know what you mean. Now, I need to talk to you about that Ripple address you sent me, but we'll do that off. Maybe talk to you on WhatsApp or something like that, and we'll talk about that.
Yeah, don't do anything because I just created that account and that gave me an option to do that. So I don't want you to do anything right now. So yeah, we'll definitely talk on that.
Yeah, that's fine. That's fine. So, did you create an Exodus wallet or anything like that, or?
Yes, I did. Yes, I got
Okay,
my
okay.
phrase that I'll never forget
Perfect.
because I live
Perfect.
it.
Perfect.
I live it. I breathe
Make
it.
sure and write that down and put it somewhere safe.
Right. Right. Never forget. I know. Got a whole book of passwords that's growing quite high now. But that's how we got to do it now, right? Everything is technical.
Yep. All right. Well, see you guys next week. Same time, same place, same channel.
Thank you very much, Glenn. I appreciate you coming. I
Thank
know
Thanks
Michelle
you.
does.
Thanks for your interest.
Sounds good. You have a good weekend and put your feet up and enjoy life in that nice weather you have down there in 80 degrees.
I know, it's nice. It's about time.
Yeah, we deserve it. We
It
deserve
won't be long until it's like 100, and then it'll be too hot.
Yeah, I'll be swearing then. Okay, take care, my friend.
All right, take care, you guys. See you next week.
Ciao, Glenn.